Good afternoon, everyone. This is Adriana Cross with A Cross Law Firm, PLLC. I'm based out of Chicago, Illinois, and I just wanted to do this quick video today to clear up some misconceptions about consumer bankruptcy, Chapter 7 and 13. As always, these videos are purely educational, informational. No client attorney relationship is formed, and if you're interested in pursuing any type of legal matter, whether it's bankruptcy or anything else, always seek counsel. If you're in Chicagoland area and you're interested in bankruptcy services, please feel free to go to my website, acrosslawpllc.com, or you can email me at info@acrosslawpllc.com. So we'll just go ahead and we'll just jump into it. One of the biggest misconceptions, and it's very passionate, it applies to me personally too, is the idea that student loans cannot be discharged in bankruptcy. Now, the bankruptcy code does actually state that student loans are not generally dischargeable. However, there is a caveat that's not widely spoken about. And that exception is that student loans can be discharged if the person will suffer an undue hardship if forcing them to pay the student loans causes an undue hardship. Now, the big issue here is what constitutes an undue hardship. Now, typically that's up to the judge, and a lot of the times the judge says no undue hardships, but obviously it's on a case-by-case basis. There's no uniform regulation as to that or uniform decision as to that. So it's typically denied. But however, there is one thing that's frequently applied, and it's called the Brunner test. It's one of the tools used to determine if a person is suffering an undue hardship. So let's just go into what the Brunner test is. It basically says, just evaluates and is a balancing test of several factors. And one is, would the person be able to maintain a minimal standard of living if you had to repay your loans? So with that being said, a minimal standard of living doesn't mean that you wouldn't be able to afford where you're currently staying. The court will also often say, hey, if you're paying $1,000 a month in rent, move somewhere where you're paying $400 or $500 in rent. I know it sounds pretty unreasonable and pretty tough, but it's also one of the primary reasons that a lot of people don't qualify for any kind of bankruptcy relief with student loans. The second part of the Brunner test is, are the financial difficulties you face temporary, or are they expected to continue for several years? With that being said, if you're just having a bad year, or that's completely up to the judge. The judges can say, hey, are you still able to, after 6 months, 3 months, however long, to pay your student loan? Typically the answer will be by the judge, yeah, you'll be able to do it. So that's another reason why it's a very hard wall to get over as far as getting bankruptcy relief within your student loans. And the third part of the test is actually, have you made efforts to keep up with your payments before filing for bankruptcy? Now, your history as far as any defaults, any delinquencies will also play a role in this. And I know people all over the United States are, have at one point or another had to either default or be delinquent, or have suffered some type of situation where they weren't able to always 100% of the time make their on-time payments. So that's another road that would absolutely get into the way of the being able to get relief in bankruptcy. So that's just a thing. Like, generally, yes, student loans are not dischargeable in bankruptcy, but if you can overcome those 3 hurdles, which are very hard to overcome, the judge may say, hey, maybe this person should qualify. But right now it's a very hard test to get past. With that being said, the next thing I want to discuss is the effect bankruptcy will have on your credit. So I've seen people say, hey, I'm not going to pursue bankruptcy due to the fact that it's going to destroy my credit. It's going to be on my credit report for the next 7 to 10 years. That's not 100% true. I've known several services, both debt negotiation, debt counseling services, credit repair, that can get bankruptcies removed from your report. So there's always those options out there. But however, when going with these options, I always advise people, please seek a service with either a licensed attorney in your area or with a service that provide licensed attorneys, because you don't want to be negotiating by yourself and then have the creditor come back and say, hey, I didn't really agree to that, and it could have just been something as simple as you didn't get a confirmation letter and you just went on someone's word. It's a lot of tricky things that could go in, but basically trust your lawyer before you trust any creditor. And the next thing I want to say is building up your credit with bankruptcy is very possible. Personally, I've built my credit up from a 500 to a 700 in about 6 months. I've done that before, and it's very possible. So even though bankruptcy can take a toll, like a temporary toll on your credit report and maybe your credit rating at the time, sometimes it's worth that bankruptcy, especially if you can recover so quickly from that bankruptcy. So that's another thing to always consider as well. And like I said, it's always good to have an attorney, a legal representative on your side, or someone in finance who can, with a legal background, who can definitely help you navigate those corners of your situation. So with all that being said, I hope this video was very quick and was very helpful to you today. And if you have any questions, feel free to reach out to me online. And we can, I'd love to talk to you more. So I hope all of you have a great day, and I'll hopefully talk to you later. Bye.